This week we are dealing with real and personal securities. Okay, we are dealing with contracts of security, and we're specifically going to deal with real and personal security. So we have 4 lectures. Lecture 3 is divided into 5 components because they will discuss the different types of real security. So in lecture 1, what we're going to cover the relevance of security law, and that starts on page 312 of your textbook. Then we're going to look at the forms of credit agreements, also on page 312 of your textbook. Then we're going to look at the basic forms of credit security. Okay. So why is security law relevant? So business needs capital, often in the form of credit. So in order to operate, your business will need capital. So this credit is often obtained from financial institutions. And obviously, if you want to take out a loan, you go to the bank. However, there is no guarantee that the business will be able to repay its credit and may even become insolvent. Okay, so the bank does not have any guarantee that you'll actually, or the business will actually pay back the money, or the business might fall into insolvency, meaning that it has more expenses than its assets. So financial institutions may require real or personal security in order to protect their interest. So they want to hold on to something in order to protect their interest and in order to make sure that they are repaid whatever money they put out as the financial institution. So when we speak of forms of credit agreements, credit agreements may take many forms. It can be in the form of a loan, in the form of a credit facility, or a bank overdraft. So the credit agreement creates rights and duties for parties, and the creditor acquires the personal rights against the debtor for the repayment of the loan, and the debtor has the duty to pay back the loan. To ensure that this occurs, the creditor may require additional safeguards. So it is possible to distinguish between 2 forms of credit security, and we're going to focus on the 2 forms: personal security and real security. So what is personal security? It provides for the personal rights to the creditor against a third party to ensure that payment of the principal debt is paid by the principal debtor. So the surety binds himself personally to the creditor for the performance of the principal's of the principal debtor's obligations. So with personal security, it's personal in nature. For example, you want to attain a loan, okay? Maybe a student loan, and the bank says, we don't have any guarantee, we don't have any assurance that you're going to pay the money back, okay? Ask someone to sign a surety for you, okay? Someone who we will look to if you fail to pay or to fulfill your monthly obligations, which is to pay us. That will be a surety, and a separate contract will be entered into by the bank and that third party. So that is an example of personal security. So the bank now has a personal right to the third party. So the bank, if you do not pay back the monthly installments, the bank has a personal right to claim the amount from the third party who bound themselves and say that they were going to pay in the event that the principal debtor does not pay. So that is personal security rights that the bank will have. In terms of real security, the creditor acquires a limited real right to the thing itself as security for the fulfillment of a duty in terms of the principal debt. So you go to the bank again, and you want to take out a loan, maybe for your business now. The bank will say, give us real security over the machinery in your business. Okay, maybe you have a construction company. Okay, maybe the business owns some sort of land. The bank will say, give us security. So if you don't pay, if the business doesn't pay, then the bank will attach the machinery, will attach the land and sell those properties in order to repay itself the money that you have borrowed out. So property law relates to real security, whereas the law of contracts relates to the nature and the content of personal security. Let's look at the basic forms of credit security. So if the principal debtor does not fulfill his duty, then the creditor, the bank, can use the security object to satisfy the debt. Okay, so if it was in terms of real security, then the creditor, who's the bank, can then go and attach that particular land or attach that particular machinery, sell it in order to satisfy the debt. If it's personal security, they will not go against you, but they will go against the third party. Say, for example, now summons are issued out in terms of personal security. The bank will bind both the principal debtor and the surety, the person who signed the surety, to be jointly and severally liable. So a real security right is therefore a stronger form of security than your personal right. Why? Because there is something that you can sell in order to get back what you have given out. So in this case of personal security, the creditor simply obtains a personal right against a third party. So most of the time, the bank will opt for your real security, especially if it comes to businesses, because they know that they have a hold or they have a right over something that can be sold to get back what they have given to you. Whereas with the personal security right, they only have a right to claim against a third party. Okay. Can I get a thumbs up that you guys understand what we discussed in terms of your personal security and your real security? Okay. All right. Nelisiwe, Kosimpile. Okay, let's look at lecture 2. Okay, so in this lecture, we will look at chapter 7, beginning from page 304 to 314. Okay, so what is surety? What's suretyship? So suretyship can be defined as an accessory contract in terms of which the surety agrees with the principal creditor that the principal debtor will perform his duties in terms of the contract, and insofar as the principal debtor fails to do so, then the surety will perform or indemnify the principal debtor. Okay, so if you go to the bank and you want to loan out or get a loan for a student loan or study loan, okay, and the bank says we don't have security over you paying back the money, so you need to bring in someone, okay, who we can look to pay us if you fail to pay us. So you call maybe your uncle or your father or your mother. Okay, so they come in and they sign what is called a suretyship agreement. Okay, now the suretyship agreement contract is an accessory to the main contract that you will sign with the bank. So now we have the principal debtor, who is you. We have the creditor, and we have the debt, right? Then on this other contract, we have the surety, the person who has agreed that you will pay the bank, failing which, if you don't pay the bank, they will pay the bank. So the surety will perform this duty. It indemnifies basically the bank that you will certainly pay the bank. And if you do not afford to pay the bank, then they will pay the bank on your behalf. Okay. So two contracts can be distinguished here. Firstly, the contract creating the principal debts between the principal debtor and the principal creditor, and also the second contracts, the contracts between the surety and the principal creditor. So the latter is an accessory one to the first contract. So the second contract cannot exist without the principal contract being in place. If the principal contract falls away, then the accessory contract, which is the contract of suretyship, falls away as well. Okay, so the lifetime of the surety contract is dependent on the initial contracts between the bank and the debtor, the initial debtor. Let's look at the nature of surety or suretyship. So suretyship is an accessory to the principal debt, and it means that it is dependent on the existence of the principal debt. So before liability can arise in terms of the accessory contract, the principal debt must exist. So if there's no principal debt, the surety cannot sign, because what are they indemnifying the bank against? Okay, if there is no principal contract of credit, then there can be no surety, because then what is the surety indemnifying the bank against? So in suretyship, one can distinguish between a principal obligation, okay, a loan, a credit agreement, or a hire purchase agreement, and a secondary obligation, which is the suretyship contract, which depends on the principal one. And this implies that at least 3 parties are there in the contract. Even though there are 2 separate contracts, one being the main and the other being an accessory to the main, we have 3 parties who play a role in this contract. We have the creditor, we have the principal debtor, then we have the surety. Okay, so a surety and a co-principal debtor is liable to the creditor jointly. So the person who signs the contract on or indemnifies the bank on your behalf to say that you will pay the bank is called the surety. And the co-principal debtor, the person who goes to the bank, okay, and borrows the money, is liable. Both the surety and the principal debtor, they are liable jointly to the creditor, meaning that if the surety pays the amount back to the bank, then the bank cannot follow the principal debtor. If the principal debtor pays the bank, then the bank cannot go against the surety. So it means that if one pays, the other is absolved from liability towards the creditor. So a surety and a co-principal debtor is liable to the creditor jointly and severally, since the surety has renounced the benefit of exclusion and the benefits of division normally available to a surety. Whereas a surety normally becomes liable only once it is clear that the principal debtor cannot perform his obligations. So, of the surety and the co-principal debtor becomes enforceable at the same time, and that is of the principal debtor. So when summons are issued, the creditor will then issue the summons against the principal debtor and the surety jointly. Okay. So characteristics of the principal debt. So since suretyship is an accessory contract, there must be a principal debt. So the principal debt can arise from a contract or a delix or another cause such as unjustified enrichment. So here the creditor has the right to reclaim the money and reclaim the money or the repayment of the money, and the debtor has a duty to pay back the money. In security, one is mainly concerned with the obligations arising from the contract. The contract creating the principal debt must be valid in order for us to go against the surety if there's a suretyship agreement that is signed under that contract. So surety is a consensual contract and should therefore fulfill all the general requirements for a valid contract. So Section 6 of the General Law Amendment Act states that a surety contract must be in writing and signed by or on behalf of a surety. So remember that we said that any contract, whether verbal or in writing, would be a valid contract. So a verbal contract is as valid as a written contract, but there are exceptions. The first exception, we said that if we are buying and selling land, okay, the contract to buy and sell land must be in writing. Secondly, if people are getting married out of community of property, that contract, the antenuptial contract, needs to be in writing. And thirdly, suretyship agreement, okay? As per Section 6 of the Gender Law Amendment Act, it must be in writing and it must be signed, okay? So a suretyship agreement cannot be a verbal agreement between the parties. If it's only a verbal agreement, it cannot be enforceable in a court of law. So the creation of a suretyship agreement or a suretyship contract, the document must contain, firstly, the identities of the principal debtor, the creditor, and the surety. So we must have identity numbers of the three parties that are involved in the entire transaction. But remember, with the principal contract, okay, it's only binding between the principal, the creditor and the principal debtor. And the surety agreement is binding between the creditor and the surety, okay? Secondly, the nature and the extent of the principal debt, okay, it must be stipulated in the contract. And thirdly, signed by a surety or his representative. This must indicate that he is signing in a representative capacity. So the surety himself can either sign the contract or he may sign it he may authorize someone to sign it, and that person must show that they're signing the contract in their representative capacity. Okay, look at the case of Follerman versus Madison that appears on page 309 of your textbook with regards to the creation of a surety contract. Let's look at types of surety. So any person who has legal capacity can bind himself as surety. So you need to have capacity to enter into a contract in general before you can have legal capacity to enter in surety. So all the elements that you covered under legal capacity, okay, with Mr. Kruger are applicable to when we are entering into this type of contract, which is a surety. So persons married in community of property need each other's permission to stand surety unless the suretyship is entered into in the normal scope of the surety's business. So what this means basically is if you're married in community of property with someone, okay, and maybe your friend asks you to sign a surety for them for a bank loan, the bank will not view your consent or your signing a surety as valid, or the court will not view it as valid because you have not gotten consent from your spouse. Okay, you need to get written consent from your spouse in order to stand a surety from your friend, for your friend. Okay, but in a situation where you are running a business, okay, maybe your business is the business of selling cars. All right, so the business needs a loan. You go to the bank and the application of the loan is made by the business, the company. Right, but the bank says we need a surety, and the only person who can sign a surety is yourself. You can sign a surety even if you are married in community of property, if it is in your normal scope of, if the business that you are signing surety for is the normal cause and scope of your business, of your everyday business. You do not need the consent of your spouse in order to enter into that surety agreement. Okay, let's look at a co-suretyship relationship. It arises where two or more sureties both stand surety for the same principal debt. So we're looking here at two people standing surety for one debtor. So they become co-sureties even where they have concluded either suretyship contracts at different times and unknown to each other. So it can occur where you don't take them together with you to the bank to apply for a loan and them signing a surety. Say, for example, you ask your friend this month to sign a surety for you, and they in fact do. And next week you ask another friend for the same loan to sign a surety. They will be co-suretyship. They will be in a co-suretyship relationship, meaning that if the bank wants to take legal action, the bank will take legal action against the principal debtor, that's yourself, the surety, that's your friend number one, and friend number two, the co-suretyship relationship that exists between your two friends. Secondly, they become liable in solidum, so jointly and severally for the whole amount, okay? Each liable for the whole principal debt. So it does not mean that because they co-sureties, okay, they have this co-suretyship relationship, it does not mean that the bank will ask for 50% from party A and 50% from party B. The bank will allow party A and party B to come forth and pay them. And should there be any balance that's outstanding, the bank will sue both party A and party B. Okay, should party A pay, party B will be absolved. Should party B pay, party A will be absolved. So it's jointly and severally liable. It's not on a pro rata basis. So co-sureties generally have the benefit of division of the debt amongst themselves. So surety who has paid the full amount can claim the contribution from the others. So what happens is, with your relationship with the bank as a co-surety, what happens is, like I said, there's no pro rata basis, okay? But in your relationship as co-surety without involving the bank, say you had paid, you are in a co-suretyship relationship and you have paid 100% of the debt, you can then approach the other surety person that you're in a co-suretyship relationship with and say, I have paid 100% of the debt because you are also in this relationship, you owe me 50%. So that you can speak on the side with, but with regards to the bank, you are jointly and severally liable to the bank. And then after you have paid that 100%, then you can go to the other surety and say, because we are in this co-suretyship relationship, pay me the 50% because I've paid 100% to the bank, okay? Let's look at the duties of a surety. So a surety undertakes to the creditor to perform the obligations of the principal debtor if the principal debtor fails to do so. Basically, it's an indemnity. What the surety does, it indemnifies the bank that should the person who is borrowing money from you not pay you, then I will pay you, okay? That's what the surety undertakes. So the surety's liability is determined by exactly what he has undertaken to do. So in terms of the accessory principal, the surety can rely on the same defenses that the principal debtor can rely on insofar as they pertain to the principal debt, like your real defenses. But the surety cannot rely on any of the defenses pertaining to the person of the principal debtor, such as minority or insolvency. So they can only rely on real defenses, but they cannot rely on personal defenses. Say, for example, the principal debtor becomes insane, okay? Or let's use an example of becomes bankrupt or broke, basically, and the principal debtor is not able to pay the bank, okay? If the contract that was entered into was against maybe your National Credit Act, okay, then the surety can rely on the fact that the contract is not complying with the National Credit Act. That's a real defense. But the surety cannot rely on something that is personal to the principal debtor. For example, for the fact that if the principal debtor is insolvent, I will also not pay because he simply is insolvent. It's not because he will not come out of the stage. He will come out of the stage at some point in time. So because he's insolvent, I will not pay. Okay, so that's personal to the debtor. So the surety cannot rely on a personal defense. They can only rely on a real defense. Okay. Let's look at the rights of a surety. So they have the benefit of exclusion. They have the benefit of division amongst co-sureties. They have the benefit of cession of actions. They have the right of recourse against the principal debtor, the right of recourse against the co-sureties, and the right of cession of action. So look at page 311 to 313 for a brief discussion of the rights and benefits of the surety. Lastly, with lecture 2, we're going to look at termination of suretyship. So a suretyship contract is concluded to ensure payment of the principal debt. So if the principal debt is extinguished by, for example, by payments by the debtor, or by set off, or by compromise, or prescription, then the suretyship terminates by operation of the law. Remember, we said that a suretyship agreement is dependent on a valid and enforceable principal contract or credit agreement, okay? And if that credit agreement falls away for any reason, then the suretyship agreement will also fall away. This is a consequence of the accessory nature of the contracts. So if the running of the prescription against the principal debtor is suspended, then the running of prescription against the surety is also suspended. Then the suretyship contracts may also terminate in any of the ways that contracts normally terminate. For example, your performance, if money is paid in full, release or compromise, or even through principal obligations that may still exist. The suretyship may also be terminated by prescription. Okay, meaning that the amount of time that is given to the creditor to collect the debt has now lapsed, okay, or it has passed and they have not collected the debt. That's prescription. All right. Can I get a thumbs up that you guys understand what we discussed regarding suretyship agreements? And remember, guys, if you don't understand, please send me an email. We can set up a one-on-one consultation to make sure that you understand going into the test. All right. Let's now look at lecture 3. And like I said, lecture 3 is divided into 5. Okay. Here we're looking at your personal, real security. Okay. For lectures 1 and 2, we focused on personal security. Now we're going to look at real security. Okay. With your lecture 3 divided into 5, but it's very limited information that you are given. And please focus on that information that you are given in the slides, supplement it with your textbook, yes, in order to get an understanding, but focus on your slides, okay? So let's look at real security in general for lectures 3, subsection A. So real security rights are divided into express real security and tacit real security. Okay, so express real security by contract, okay, you expressly agree to that, and tacit real security is arises as a result of the law. So express real security are created by agreements between the creditor and the debtor, and tacit real security arise by operation of the law and are created without the consent or cooperation of the creditor and the debtor. So it means that even if the parties do not agree to it or do not discuss it, when they're discussing the terms and conditions of their contract, it may still be there because it's there by operation of the law. So your real security rights are aimed at strengthening the creditor's position, especially in the case of a concurrent of creditors in the event of the debtor's insolvency. So as a general principle, every debtor is contractually obliged to pay his own debt, and his estate will be liable for proper performance. So a creditor may secure his claim for payment by means of a real security right, which will give him a preferential claim to the proceeds of the object of the security. So the real security holder can have an object sold in execution, and only when his claim is satisfied can the unsecured creditors claim or be free to claim from the residue. So the real security holder can also prevent the debtor from disposing of the security objects. Remember, we said that with real security, the creditor is attaching an object, some sort of property. And when you as the debtor don't pay the money back to the creditor has the right to then sell that particular item, okay? But we have what we call preferential creditors who have the first right to sell it. And whatever remains, the other unsecured creditors can then help themselves from it. So a real security holder can prevent the debtor from disposing of the security. So usually when you enter into the contract of real security, it has that clause in it that says that you are not allowed to sell or donate or give to someone else any property that the creditor has real security in, because you're giving away that right of the creditor to then sell that particular item in order to recover what is owed to them. It is important to distinguish between the different parties as well as the different agreements that are relevant in conventional real security rights. So the parties are usually the security holder, okay, the creditor or the credit grantor, if you want to call it that. Secondly, the security grantor, which is the principal debtor or the third party. So in a security transaction, the following legal facts can be distinguished. Firstly, the loan agreement is the principal debt. Secondly, the security agreements, the creation of security for the debt. And thirdly, the constitutum, which is the vesting of the limited real right. So the person who furnishes security is usually the debtor, but this need not be so, since it is possible to provide security for another person's debt. So let's look at the general principle of the security agreements being accessory in nature. So the security, real or personal, is accessory to the principal obligation. So all real security rights are accessory in nature. This means that security rights cannot exist if there is no principal right in law. So if there is no principal debt or no principal rights, then the security contracts will not exist in those instances. The principal debt may arise from a contract or a delict or in however form that it arises in. It may also arise from a natural obligation or an obligation which is subject to a time clause, okay? And with regards to the explanation of the surety agreement or suretyship agreements being accessory in nature, look at the case of Kilburn versus Estate Kilburn, which appears on page 315 of your textbook, okay? Let's look at security objects. So the security objects refers to the thing that is the subject of the pledge, and any movable or immovable property that is part of the commercial world can be an object of real security right, okay? So it can be something that can be moved from point A to point B that can be attached as a security right or a real security right, or it can be immovable property such as land that can be attached for that real security right. So it can be a single item or a composite item, okay? It can be just one thing, maybe a bag, okay? Or it may be something that's made up of a lot of other accessories in it, okay? Or it can be incorporeal things as well, such as your shares, things that you can't see, touch, or feel with any of your five senses. So it must be clearly determined or described in the agreement. So the specificity of the principal object must be described in the agreement. So if it's a cell phone that you're attaching, it needs to be described what model, what year, what color, it needs to be described. If it's land, the address, the earth number as it appears in the title deed, it must be described as that. So unless there is an agreement to the contrary, they secure the entire claim. So the creditor secures the entire claim for what you have taken out. They will sell that object to get what you have taken out back to them, okay? Can I have a thumbs up that you guys understand or have a slight understanding of what real security is as opposed to personal security? Remember, real security is when a thing is attached. So property is attached. okay? And property will be sold in order to satisfy the debt. With personal security, it's personal in nature. It gives rise to personal rights, okay? So the creditor will only have the right to claim from the third party amounts that is due, that is owed and payable by the debtor. Do you guys understand? Luyanda? Nadia? Okay, let's look at lecture 3, section B. And here we're going to talk about a pledge. Okay. So when dealing with express real security rights, it is usual to distinguish between a pledge and a mortgage. So in the case of a pledge, the security holder, who is the pledgee, takes control of the object of security referred to as the possessory pledge. So in the case of a mortgage, for security grantor, the mortgagor then remains in control of the thing. So a pledge can be defined as a limited real right over the pledge's thing that is delivered to the pledgee as security for repayment of the principal debt. And the pledgor then retains ownership of the thing, and the pledgee acquires the limited real right to the same thing vested by delivery of control on the thing to the pledge. Let's look at strange clauses that you can find in agreements where pledge is discussed. So in agreements between a pledgor and a pledgee is that the pledgee, which is the creditor, may buy the thing at a specific price, okay, which is valid both in the mortgage and in the pledge, provided that it was made after the debt has fallen due, or where the agreement preceded the due date, only the pledgor at the time of non-repayment is prepared to pay part with his ownership of the thing at the agreed price. So the pledgee is the creditor, and in acquiring physical control, the pledged thing, on the pledged thing, the pledgee acquires a limited real right to the pledged article. So the right enables him to keep the thing in control until the pledgor has paid the principal debt. So in case of involuntary loss of control, the pledgee can claim it by means of real action from whoever is in control of the thing, even if it's a bona fide purchase. So if the pledgee then voluntarily loses the control, he cannot have this right to claim from the bona fide third party. He will lose that right as a pledgee. And if the pledgor is unable to pay the principal debt, then the pledgee may obtain the judgment against him and have the thing sold in execution by the sheriff or the messenger of court. And if a summary execution clause is included in the pledge agreement, then the pledgee can then proceed with the court order. Then the pledgee can satisfy the principal debt from the proceeds, but must pay a surplus to the pledgor. Okay, so I think that you guys need to familiarize yourselves with the terminology. Who's the pledgee? Who is the pledgor? So the pledgor is the person who gives up the thing, who pledges the thing, the debtor. And the pledgee is the person whom it's pledged to, the creditor. And the creditor has the right to have a pledge right to or a hold over that particular property. And should the debtor, who is the pledgor, okay, should the debtor not pay the creditor, then the creditor has the right to sell it. It's a form of a real security over a property. It's a pledge, okay? We're also going to discuss mortgage bonds because mortgage is also another example or a type of a real security right, okay? Okay, let's look at cession. So security by means of claims is very important. It's a very important form of security in modern commercial dealing. So for many businesses, the most important assets are not land or movable things, but incorporeal things such as shares, because they deal with shares. People buy and sell shares on the market on a regular. So in business, the important assets of a person are claims, right to the creditor, or the right that the creditor has over the debtor, and claims can be sold and transferred by means of cession. So cession can be defined as an act of transfer in terms of which the creditor transfers his claim against the debtor to the cessionary. So a claim as an incorporeal thing can sometimes be the object of the real right. As in the case of the pledge of corporeal things, in a pledge of claims, the pledger retains ownership of the claim. With the cession, only the quasi-control of the incorporeal thing is transferred to the pledgee. So there is also a publicity requirement which must be fulfilled by notice of the cession to the debtor of the cedent, since the debtor is the person most directly affected by the cession. Okay, like I said, guys, the topics that are discussed here in the slides, familiarize yourself with the topics, and you'll find that the topics that are dealt with here merely terminology. So what is a pledge? What is cession? Okay, I think we're also going to deal with mortgage. What is a mortgage? When does it happen? Okay, and the parties to that particular agreement. And remember, these are all types of real security. Okay, notarial bonds, another example. So the security by means of movable property in terms of Act 57 of 1993 makes provision for the registration of notarial bonds over a specified corporeal movables. So the Act excludes incorporeal movables from its operation, and it appears that it also excludes a special notarial bondholder of incorporeal things from enjoying the preference bestowed on the special bondholder of movable registered over the commencement of the Act. So a security interest in movable property may be created by registration of a notarial bond in the Deeds Registry, and Section 102 of the Deeds Registries Act defines a notarial bond as a bond attested by a notary public and hypothecated movable property generally or specifically. So we need to distinguish between a special and a general notarial bond. So what is a special notarial bond? The legal consequences are governed by the security by means of your movable property Act 57 of 1993. The special security bonds operate in the same way as a pledge, although the debtor is not required to deliver the property to the creditor. So the Act requires the property to be described in a way which renders it readily recognizable. So it must be clearly distinguished what property it is. The test for determining where the asset is hypothecated can be identified on the ground from the description on the bond alone. And your general notarial bond, it is possible to have a notarial bond that hypothecates movable property generally. However, the commercial value of such a bond is limited due to, firstly, the fact that the mortgagor can dispose of the property to a bona fide third person free from the bondholder's rights. If attached by another creditor, the bondholder cannot prevent the sale in execution and has no preferential claim to the proceeds of the sale. So a perfection clause entitles the bondholder, who is the creditor, upon the default of the debtor, to take possession of the movable items over which the bond is registered. And by obtaining possession of the movable property, the bondholder perfects his security and consequently has a real or a secured right of a pledge in respect of that particular kind of property. Okay, guys, familiarize with your terminology with regards to notarial bonds. And when notarial bonds, we are looking at attaching your corporeal movable things. Okay, we are looking at attaching your corporeal movable things where one person, okay, needs to pledge over basically his movable things to the creditor, and should the debtor fail to pay, then the creditor can then sell those items in order to satisfy the debt or the debt amount. And what makes it different from a pledge is that in a pledge, the items will have to be delivered, but in notarial bonds, the item does not have to be delivered. The item merely needs to be properly defined, okay? It needs to be described in the contract. Okay, can I get a thumbs up that you guys understand what we've went through so far? Okay, let's move on to the fifth section on part 3, that is mortgage bonds. So mortgage bonds or deeds are the documents embodied in the terms and conditions of the mortgage. And in this narrow sense, a mortgage refers to a real security right where the creditor is not in control of the object of security. So a conventional or express mortgage is established by the mortgage agreements between the mortgager and the mortgagee together with registration. So owing to the accessory nature of real security rights, there must always be a principal debt to it. So immovable things may be burdened by mortgage bonds, such as your houses, okay? So if you go to a bank and the bank gives you a loan to purchase a house, the bank will put a mortgage bond over that house. So the bank will be a preferential or preferred creditor. And so much as that if you don't pay the bank will then attach that house, set it in execution, and recover what is owed to it. Okay, so a special mortgage can be distinguished only with regards to a particular immovable thing such as land, including land with buildings on it, and cannot be established over immovable of the debtor in general. Okay, it is the deeds registry's practice to endorse the existence of a bond against a title deed. So you'd find that the title deed will be endorsed that there is a bond over this property. Okay. A costing brief can be defined as a special mortgage over an immovable thing to secure a principal debt that has been incurred in respect of the purchase price of that thing. So the deed of hypothecation can be registered simultaneously with the deed of transfer of a particular thing. And when we look at a covering bond can be defined as a special mortgagee or mortgage securing a future debt. So it must be expressly declared to secure a future debt, and not the maximum amount, but it must be stipulated in the contract fully that we are now securing a future debt and not a debt that has arisen or a debt that has become effective at that point in time. So the preference conferred by this bond is determined by the date of its registration and not by the date on which the debt has incurred. And the object of the security will determine the type of bond. Let's look at the operation of mortgage bonds over immovable things. And in establishing a special mortgage over immovable things, the mortgagee then acquires the limited real right over the mortgage land and also over the attachments to it. So although the mortgagee is not in control of the mortgage land, the mortgagor cannot transfer ownership or establish any other real rights over the mortgage land without the mortgagee's consent. Okay, just like you cannot sell a house that has a mortgage bond over it, okay, because it's locked basically. The bank will not allow you, and you need the bank's consent in order to sell it. All right. As soon as the mortgagor discharges his debt to the mortgagee, the mortgage is extinguished and the bond is cancelled. So as soon as you finish on your last payment of your installment, okay, then the mortgagor then discharges his debt, and the mortgagee then can extinguish the bond. Okay, the bond will then be erased from the property. You can freely sell the property without getting consent from the bank. So the mortgagor is entitled to pay his debt and discharge the mortgage before the date of payment provided for, and that also he pays the interest in advance up to the date of payment. So you see a little bit of credit agreements coming through here, meaning that if you are given 20 years to pay off your house, your loan for a house to a bank, you can actually pay it in 10 years, and the bank must allow you to pay it within that time. And you can, in the process, kill interest. You are allowed to kill interest by paying more than you are supposed to. If, however, the mortgagor fails to pay the whole debt on the due date, then the mortgagee can obtain judgment against him. The mortgage thing can be declared executable and sold in auction. So usually the banks will give you 3 months, okay, for you for your defaults. And on the 4th month, they will go to the court and ask the court to make the property executable, and they will show that they are the mortgagees in the contract, and then the bank will make it executable. They will sell it, and then they will retain whatever they had lent to you for you to buy that house. So the above process is referred to as a foreclosure. So you'd say that the house has been foreclosed. So the Constitution of 1996 prescribes certain protective measures that the property to be sold in execution is the primary house of the poor or the elder or the sick or minor children. So the right to adequate housing under Section 26 is also considered, and there must be an order of court that looks at various factors. Okay, so the mortgage does not make the mortgage thing in any way immune to be attached from another creditor who has obtained judgment against the mortgagor. However, the priority principle gives him the right to place the reserve price on the mortgage thing. And if the mortgage thing is sold in execution by the mortgagee as a preference in respect of the proceed of the payment of his claim, then secured by the mortgagee. Okay, so a further important development took place when we saw Section 26, subsection 3 of the Constitution, where no one may be evicted from his home without the court order, which has to be made after all relevant considerations have been put into account. And this means that the clerk or the registrar of courts may not grant a default judgment where the primary residence of the mortgagor has been declared executable. So what happens is, if that is your primary residence, it's not your holiday home, if it's your primary residence and that's where you spend most of your days with your family, then certain relevant factors need to be considered in terms of Section 26, subsection 3 of the Constitution. The court cannot readily grant the house to be executable, okay? Executable meaning that it can be sold in a public auction, all right? Guys, I quickly want us to look at the last section, which is lecture 4. Can I just take 5 minutes of your time? And here we're looking at the real security or tacit real security. And the tacit real security, some real security rights arise by operation of the law. And tacit real security may be constituted over movable or immovable things. Unlike your expressed and conventional mortgagees are dependent on the creditors and the debtors allowing it to happen, or they expressly agree on it. So sometimes it's called a legal mortgage. So examples of your tacit real security will be your tacit hypothecs and your liens, so your right to retention. So what is a tacit hypothec? So to secure an area rent, a landlord has a tacit hypothec over movable property which were bought into the lease premises. When we spoke about lease agreements, we touched on this. We said that the landlord may has a tacit hypothèque over the movable property that is brought into the leased premises. And if you fail to pay rent, then they can sell the property to satisfy their rent. And all the things belonging to third parties are also brought into the premises by the tenant and are subject to the landlord's tacit hypothèque. And I made an example and I said that if your friend has a laptop in there, that laptop will also be subject to the tacit hypothèque, and the landlord would have to prove certain things, that the third party knows where the property is, and secondly, the property is unintended for the use of the is intended for the use of the tenant, and it has been there permanently. Okay, so the landlord's tacit hypothèque comes into operation as soon as the rent becomes overdue, and the landlord would attach movable property while they are still on the premises and while they are in a process of being removed for the sale. So a lien can be defined as a limited real right to secure a claim of a person who has spent the money or done the work on another person's thing. It entitles the lien holder to keep the thing until the debt has been paid. So liens depend on the physical control of the thing, and liens apply to both movable and immovable things, and no formalities are required for the creation of a lien. So since a lien is an accessory real security right, there must always be a principal debt. The lien holder must be in actual physical control of the thing. And possession is constituted by physical control plus the intention to derive to a benefit. So to hold the thing as security until the repayment of the debt is paid back to the creditor. So the expenses which one may incur in respect of another person's thing is divided into three. We have essential expenses, we have useful expenses, and we have luxurious expenses. So know what are essential expenses, what are useful expenses, what are luxurious expenses. Also know what are the examples of each. Let's look at what an enrichment lien is. So on the ground of the principle that there is no one who may be justifiably enriched at another person's expense, no one who incurs essential or useful expenses in respect of another person's property has the right against the owner of the thing for compensation of the expenses. So since he can be regarded as an unauthorized manager of another person's affairs, this applies even when he did not obtain the owner's consent before incurring the expenses. So in order to secure the claim, he is entitled to retain the thing until he's compensated for the expenses. And if those expenses are essential, then that is a salvage lien. And if they were useful, that's an improvement lien. So the doctrine of unjustified enrichment applies to essential and useful expenses only, and not luxurious expenses. Lastly, let's look at your judicial pledge. So a judicial pledge arises when the sheriff attaches the judgment debtor's movable or immovable things in terms of the court order to sell and execution. So the attachment of the movable by the sheriff has the same effect as the pledge, and the attachment of immovable thing has the same effect as a special mortgage over your movables. So the sheriff must first attach the movables before immovables are attached. Okay, guys, make sure you understand the terminology. And again, if you feel like you don't understand, please email me. Let's set up a one-on-one consultation. Let's discuss it before you go and write the test. Okay, if there are no questions, we will end the lecture here. Are there any questions?